I really mean these vignettes to be something for you to think about. I don't think that necessarily they have actual, in all cases, specific answers, although I think some of them have some very specific answers. But I really wanted it to be an opportunity to talk in general about issues in these cases. And I think it's of tremendous benefit to have other people in the room that do what you do, that practice within the same framework that you practice, and to see that sometimes there may be a different perspective in how you're looking at things. I certainly do not intend to be here as sort of some ethics guru that's going to give you the answers to everything, but I think there's a value in being from out of town and raising some questions about this is what it says, and how does that really work for you in practice, and are these guidelines something that you are in fact following. So with all that in mind, none of the questions have an answer that I'm going to hand out to you. I just would like to talk about them. Let's talk about this first vignette. You've got a client, a child, who's in foster care. She tells you that she is getting to see her father when she goes on visits with her mother, and that she wants to see him, and there's no problem. She's not telling you this because she's unhappy with it. She's telling you this because she's happy that she's getting to see him. She wants to see him. There's no problems. There's no worries about it. But you know that there's a court order that says that she's not supposed to be having any contact with him at all. The child says to you, now don't tell anybody about this. Nothing bad is happening on the visits. Aren't you supposed to be keeping my secrets? How are you going to analyze what to do here? She's first of all asking you a question and telling you she doesn't want you to tell anyone. And second of all, you've now learned some significant information that the father is in violation of a court order. Let me ask you how you analyze it. What's your, are you thinking there's a problem in the best interest area? Does it make a difference in your mind why the judge said no contact? Do you think you have to tell the judge? I feel like I'm going to have to start picking on people. Yes, ma'am. You feel you have to be addressing it, meaning you have to tell the judge. So I was interesting to me that you said something about the caseworker, that in essence, would you say the caseworker might be one of the first people you would call? What are the circumstances of this visitation that this could be happening, in effect advising the caseworker that this is going on and that there could be a problem?
Well, part of the bus staff with them,
yeah.
The custodian.
Yeah.
And in our case, I go to the private, so I get over to ABC first, and then they need to, put the screws on, and then file a motion with the board.
Would you be anticipating that they would file the motion, or do you think that's your job to do? You'd file the motion.
Yeah.
Okay. And what do other people think about who to contact first? I had two other answers in Omaha. One person thought that they would call the father's attorney and tell the father's attorney, just so you know, I'm about to tell people that your client's in violation. Someone else said, no, the first person I would tell is the judge. I would go to the judge right away, candor towards the tribunal, and say, you need to know that I've received information that your court order's in violation.
I've got a bigger problem with violating my client's confidentiality. I think I go to the Bar Association first and go to their council on discipline and say, this is the situation. Can you assure me that I'm not violating the code of ethics by reporting it to anyone? Because I'm not too sure that we have an obligation to report a potential violation of the court order to anyone.
So part of your analysis would be, right, part of, yeah. Right. And part of your analysis is, at this point in time, even if there is a violation of the court order, I'm not analyzing that that's in some way harming my client's best interests, so I don't know that I would need to do any disclosure.
Right, unless she is saying something that leads me to the conclusion that she's being abused.
And being hurt in some way during these visits. All right.
And she isn't telling that.
Yep.
So that's the person.
So the first person you're going to contact is someone in the Bar Association saying, what's my ethical obligation here to even tell anyone?
License for violating my client's confidence.
Well, I think that really does get to the issue about the duality of our roles in Nebraska. Because I think that as guardian ad litem, I may have a duty to disclose. Hopefully, I've had a conversation with this child beforehand, explaining that I'm not going to keep secrets here in my role as guardian ad litem. Now, if this comes out and I haven't done that, I'm probably going to use this as an opportunity to say that. And I don't know at what point it comes in conversation, but I think I would tell the child, and then tell the child they have a right to have an attorney appointed in this matter if they apply. I think that you also then get to John's analysis of is there harm being done here, and balance that with the need to disclose that there's been a violation.
I think that that's right. It seems to me that there seems to be a different assessment here. It may be true that although you've discovered a court order is being violated, it may not change your assessment about best interests. At least at this point, what you've been prepared with, what you've been informed by your client is, although this violation is taking place, she's not feeling that she's at any kind of risk or harm. But I think the original analysis is, I would need to know what's going on. Is that because someone is actually there? Is she seeing this person in some way? One of my questions is, would it make a difference to you if you thought that mom didn't know what was going on as well, meaning that somehow she was seeing the father without anyone knowing that it was occurring? But also, I think, the point of the facts is that it does challenge, I think, this duality that you have. I do think one of the things that you're going to have to consider if you are going to tell other people about it, if you feel obligated to do that, is that she has told you she wants something that maybe your feeling is not in her best interest. And it may be not only important to underscore the I don't keep secrets based on what I've been told by statute is my role as a guardian ad litem, but if you want to pursue this seeing your father, and I don't think it's in your best interest, then maybe we do need to see about getting you an attorney. And I would assume an attorney would have to bring on some kind of motion to make that argument that you might be choosing not to make. If you then analyze your best interest and said to yourself, I don't know why the judge ordered it anyway. It's really not necessary. As long as this was being supervised by a caseworker, I don't really think it needs to happen. Then maybe you're joining the child's position with your best interest. And you're now saying, all right, I'm going to make an argument before the court that the court order should be changed and that you should be allowed to see your father in some supervised way. This statement about you're supposed to keep my secrets, I think, as well, raises this question about how carefully have you helped this child understand that, and are you going to need to repeat it again and again for the child? One thing that a couple of people have mentioned to me in showing this vignette is that they said, it might be very helpful for the child to understand that this could be a problem for the father, and that she needs to have some understanding now that because she's told this, probably there are going to be consequences to her father, and that might impact her relationship with her father, other kinds of issues as well. I'm concerned about her. She wants to see the father, but the father has done something pretty serious, violated a court order, and she's told about it, and there's going to be some consequences that happen to that.
There would also be consequences with the mother. There definitely would, because either A, mom doesn't know and is not aware of chance of visits, or B, mom does know and is helping a violation.
Yep. So it might not make a difference to you what you do based on the fact that mom doesn't know or knows, but it might make a difference to what's going to happen in the future. And again, the child may need to understand and know about this. This is hard though, isn't it? Because in my mind, the child is told something really important. The consequences to that now may be such that the child's lesson is, I guess I better not tell anybody anything.
Well, that raises a question to me is, I don't know any other area where the client isn't the person that can waive the confidentiality requirement. How can you explain to your client before you start doing anything, there may be times when I'm not going to treat you as a confidential, we're not going to have a confidential relationship.
Right.
Beforehand.
Right.
How can you do that?
Well, it's hard to do, especially if you get really young.
That
is correct.
Any other legal relationship, can you waive your client's right to confidentiality? It's only the
Right. And when you look at the Supreme Court rules and they talk about informed consent to waive that confidentiality, what does that mean? I've told this 7 or 8-year-old this several times. Maybe that means something at the moment you're telling it, but...
Yep. You can't tell them that you're going to waive it.
Right.
You have to ask their permission to waive it.
You're right. I think it is an issue. I mean, it's the reason why we're sort of sitting here discussing these issues, because I don't think there's an easy answer. And it's not like anything else. You can't really say, this is what I do in other kinds of scenarios, because in no other scenario as an attorney do you have this issue.
And again, that's why whenever I've been appointed guardian ad litem, that is a continual, I mean, it is a continual conversation I have with the juveniles. And I just say that there is no confidentiality. It's just, by telling them that straight out, I don't have a problem when they think, well, but this is something that you don't have to say. I just tell them that things are going to be recorded. And most conversations after that, I refer back to that prior to having discussions.
I think in talking about this business of seeking an attorney, this is the kind of thing that would really make me want to process that, talk to somebody else, analyze it, because I now have a client telling me that she thought I was going to keep a secret, even though I thought I told her I wouldn't do that. And now that telling me of what she thought was going to be a secret is something that's going to become a big deal and is not going to go the way she wants it to go. She's not understanding the relationship. These are things that are piling up in my mind towards the idea that maybe she needs an attorney at this point. But to a certain extent, the cat is out of the bag because you're operating as both the attorney and not. Is there any way that you can look at this picture and say, as this gentleman is arguing, maybe you don't have to tell anybody? Does anybody think that that's possible, that you could say, you know, if I analyzed it and really didn't think he was a threat, then I don't have to tell? Would everybody claim that they were operating in a courtroom setting in front of a judge who is expecting that you would not keep to yourself information that somebody had violated a court order? I'm not seeing any responses, but I'm guessing that's true. Are you practicing in front of a judge who would be horrified to think that you would not inform him or her if one of the parties was violating a court order and you knew it?
I don't know if it's violating the order so much. Is the fact that child is at risk.
But we don't know that. The way this is written.
I say that child is at risk.
Yeah.
Because under going back, whether mom knows or not, there's contact that has been banned.
Yeah.
That's occurring. And at some point, that, you know, that was banned because it was considered to be a concern.
Yeah. I mean, but that's sort of my second question. Does it matter to you why you think the judge issued the order? You know, whether you think the judge issued the order to protect the child or whether you think the judge issued the order for other reasons that you don't necessarily agree with. I think it's, you know, the analysis is out there in my mind about whether or not, from a best interest perspective, you think your position has now changed, and whether or not you think that this client may now need a lawyer to advocate for something quite specific that she wants, that is contact with the father. Maybe not if you also agree that that would be in her best interest and make that argument. Let's take a look at this one. This one maybe is a little bit easier. A relative comes forward. She doesn't have a lawyer. Let's say it's an aunt. She says that she would be glad to take the children temporarily, and she does not ask about becoming a foster parent or anything about foster care subsidies. Are you obligated to tell her that she might be able to get more money and more services to care for the children if she was able to obtain a foster care subsidy? Or should you tell someone else that they should tell her about this? She has no lawyer. She's coming forward. She's interested. And analyze it this way, from your best interest perspective as well as your lawyer perspective. Are you obligated to talk to this woman about it? Should you refer her to somebody else? Some of you must have had this happening to you. She doesn't have a lawyer, you don't want to become her lawyer. She don't want to give her legal advice, right? Is this legal advice? Yeah.
I think I would mention it because I would see that subsidy as in the best interest of the child to have that support. So I think I would mention it, but be very careful about the line of giving her legal advice.
So you think that you would say, my analysis is it may well be in the best interest of my clients to have a placement option where there's more money and more services. So I'm going to ask her if she knows about this. I'm not necessarily going to tell her to do it or not do it, but ask her if she knows about it and maybe refer her to somebody, caseworker, to learn more. I think that's a good idea. Anybody have any other kind of argument? Does anybody think that, you need to walk away and not speak to the person at all in the context of giving legal advice? One of the things that the Bar Association rules, the Supreme Court rules say about talking to someone who's unrepresented is to try to make clear that you do not represent their interests and that you are representing, in fact, a client. So I think that might be a good way to open it up. What about the second half of it? She is told about foster care subsidies, but she says to you, oh, I know about that. I do know about that, she says, but I'm really sure that my sister is going to be able to resolve her 10-year-old drug problem quickly. And so I don't want to go through all that bother. This is only going to be a month or two. Do you have some obligation, or do you think it's inappropriate for you to discuss with her the ramifications of that? You're sitting there thinking, this child is not going home in a couple of months. These children are going to be out of the home for a while. I question whether they're going to go back at all. And I'm concerned that this relative doesn't really understand that. Are you going to say anything at that point or direct her to any particular person?
I think it'd be important to some extent to feel this person out on, okay, let's say it wasn't 2 months, let's say it was 6 months, let's say it was a year. So then that way, if, HHS says, hey, we have this person we want to consider in this placement, they come to me as GAL and say we want a position, I'd like to be able to say, yeah, I think she'll be fine because she understands and is willing to accept a longer-term placement, or I have issues because she's going to want these kids out of her house.
That's a really good point. In other words, you're saying her comment on this makes me worried about more things than just money. It makes me worried about whether or not she really is a good placement if she's thinking that it might only be a few months, and I'm thinking it's going to be a lot longer. I think that's a really valid point. Yes, ma'am?
I think you should talk to her about that, because if she thinks it's a short one and it's not, and then the child would have to be placed someplace else because they thought it was going to be a short one, I think if you're going to represent the children, you have somewhat of an obligation to make sure that they don't have 3 or 4 placements.
Yeah. I totally agree with you, and I think the money factors into this discussion. It's not just is she hinting or saying that she's only willing to take the children for a couple months, but would the additional money and services available as a foster parent help her extend that if that was going to be necessary, and what does that mean? I think this is something I would not walk away from, because I would be analyzing this as this conversation is in the best interest of my clients. Even though I don't want to give her specific advice, I'm concerned that she doesn't know this. If you did not know, the federal law Fostering Connections and Success Act requires that caseworkers give this information to all relatives. So one of the other things you can do is say, you're entitled to know about this information. That sounds like you don't really know it. Let's see if we can get the caseworker here to give you better information about how that's so. The other thing that I would say about analyzing this thing is, I've not put in here anything about how the child feels. What if you were aware that the child strongly doesn't want to be with this relative, does not want to be placed with this relative? Is there a problem in your helping the relative understand better how to be a good placement resource if you are aware that your client does not want to go with this relative? What your lawyer had say about giving advice to this relative. You have a dual role. You have to think about it from both perspectives. The best interest one, but also from the lawyer perspective. I think this is something worth thinking about. I do. If the client feels strongly that it shouldn't happen, I think you would analyze whether or not you want to talk further with the relative. But I also think there's a couple things you can do to analyze that situation. Although your client might not want to be placed with a relative, if your assessment is that it is a possibility or even a likely possibility, then assisting that relative to have more funds available still seems like an appropriate thing to do. It doesn't seem to me that you're going to want to set the relative up for failure to try to assist your client when it's possible that the judge could do that. But I do think that you might, from your lawyer perspective, again, based on the Supreme Court rules, that you're supposed to let an unrepresented parent or unrepresented person understand that you are not an independent person, but you have a client. You might want to advise the relative, I'm not sure that I will be supporting you are taking these children, but I would want you to find out more information about that. Perhaps you need to disclose to this relative that there may be a question about whether or not you're going to. I wouldn't want to tell the relative, my client says she doesn't want to be with you. It seems to me that that's violating confidentiality when it's not necessary. And when you're representing a person whose capacity is diminished, then it does say in the rules you should only release information that's really necessary to do what you have to do. I don't know that you would need to release that. Okay, let's take a look at this one. Maybe this has never happened to you, but I'm old and this stuff used to happen all the time. You're handling a contested hearing and you realize that one of the other attorneys has been drinking and appears to be somewhat impaired, but for whatever reason nobody else is noticing it. Maybe you're close enough to smell the breath, or someone isn't paying a whole lot of attention. What should you do? What should you do? You're in the middle of the hearing and you see that this person is impaired. Anybody ever have this happen? I asked that in Omaha and they assured me no one drinks in Omaha, so never happens. We talked a little bit about the requirements to inform when someone is in violation of the rules. I don't know if you've read that recently, but I think it's in your packet. If not, I'll tell you what it says. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. Do you think sensing that your opponent has been drinking and is impaired by it means that they are violating their rules and need to be reported? What would you do? Do you think you need to report it immediately to authority, or do you think you might try to, for example, ask if the court would let counsel meet in chambers, have a discussion with the attorney and the judge, try to bring it to the judge's attention that it appears as though this attorney is impaired in some way? Is that a way to handle it? What if you think it's the judge who's been drinking? This one got a little bit of a stir, so maybe someone's like, what if you think it's the judge who's been drinking? You know, one of the things to think about in the context of representing your clients is cases that are successful could have an appellate response in which some issues like this are brought up. Incompetent counsel, you know, the judge was under the influence. If part of what you want to do is make sure that this case doesn't drag on and on for children, doesn't get reversed on appeal and have to be retried, I do think you want to, from a standpoint of representing your client, even if you're thinking that the ethical rule might not apply, from the standpoint of representing your client, I think you want to do something. I would recommend that you might want to, in either case, the attorney or the judge, even if you've decided it's not significant enough to report to the ethics board, although I think it is, but even if you decided that it was not, I think asking for a meeting in chambers and strongly suggesting that the case be adjourned until a day when counsel is in better shape or the court is in better shape, as scary as that is to say, and looking for a way to protect the record from your client's perspective might be an important thing to do. Does it make any difference in your mind if the impairment is really sort of helping your client? You know, they're not doing a very good job because they've had something to drink. Maybe it's a little clear on the last line. What if you realize that the opposing attorney is misquoting the case law in this area in a way that actually helps you? Do you have an obligation to inform the court that somebody is misquoting the case law, is not cited a particular case that's significant, especially in a situation where they're missing out on something that would be hurtful to your case? What do you think on that one? Candor towards the tribunal? Do you have to tell if someone's argument isn't really not covering the issues? Actually, this one is specifically referred to.
This is such a hard one. Here you are, you're a professional, if you're in your community, you know the lawyers you're working with.
Yep.
And you know if they're not, you would know if something wasn't cognizant was not.
Right.
Then what is it? Is it, well, you say it's alcohol. You know you don't smell anything, and this and that. It's a real tough decision. I've been practicing for 33 years too, and I only had one or two of those things come up. And mainly it's been my criminal adult client that's come to and then I just have to continue.
Right. Then you don't say anything. But to me, the ethics are so clear there. You're not going to say, Judge, my client is so drunk I can't talk to him.
Gee, that's a real tough one.
Yeah.
The answer, I don't know the other lawyers. I don't know why.
I'm trying to be...
They go on though, in the courtroom.
Yeah.
They're going to impair either, well, the proceedings are going to be impaired in terms of its integrity.
Right.
I'm not going to, talk to the lawyer. I've had other lawyers approach me about situations in reference to X, Y, and Z. And then I take a look, see at the situation, but that's such a tough situation. In reference to misquoting of the law and business like that, I guess I wouldn't rely on it at all in terms of any of my final arguments. I might, do a red flag saying, my interpretation of that case law may not be the same as that, and I would move on and not rely on those representations.
Yeah.
You owe that to the court.
Yeah. The candor towards the tribunal section 3-503.32 actually uses this as an example and says that you cannot simply stand there and let somebody misquote the law. So I do think you have to do anything about that. I think your point about the drinking or someone who appears impaired is a very valid one. I think that when you're practicing law in any community, even communities much larger than yours, there is a little group that tends to be the group that does this kind of work routinely, and you do want to make sure that your reputation is one of collegiality. But I do think in this kind of a situation, what you need to do is also protect the record. What I think in these kinds of cases, in this sort of a situation, is that you need to either say something to the other attorney or you need to say something to the judge. Whether you make an assessment, I can't really tell whether it was so serious that this person really needs to be reported to the ethics board might be different. But I think what I would like to say is that I don't think you can just stand there and do nothing. I think that you have to do something. Whether you ask your opponent to say, look, it's clear to me that you're having some kind of a problem. I'm not going to oppose you asking for an adjournment. Or whether you go to the judge and say, it's clear that there's some issue going on here, we need to protect the record, and can we put this over for another day? But I really think that you can't stand there and do nothing. It does mean that you're causing at least a question about whether you're condoning the behavior and not reporting it as you are required to do, or whether you're putting your client at risk of the integrity of the hearing itself and whether it could be reversed. No, yes? No one's had any kind of an experience like this, huh? They drink a lot more in my part of the country, I guess. How about this one? I do a lot of ICWA training around the country. So this one's actually come up to me a number of times as a question that attorneys for children have asked me about obtaining information that suggests that a child might be ICWA, and there's a struggle with whether or not the information should be revealed. In this case, the child says to you, I don't want to live with my grandmother. She lives on that Indian reservation. You actually don't think she should live with the grandma either. You've made a best interest assessment, but it's based on the fact that the grandma lives fairly far away, and you think that's going to be a real problem with working towards reunification, which is what you've assessed is really the appropriate best interest for the child. So you're sort of in agreement in the sense of, I don't want the child to live there either. And you're in court, and the judge asks just sort of everyone in a general way, is there any reason to think that this is an ICWA case? Nobody says anything when that happens. Should you keep your information confidential? Can you advocate what you want without telling the court this issue? You don't have absolute certainty that it's an ICWA case. You only have this piece of information that there's a grandmother who lives on a reservation.
I think you can go ahead and say, you need to tell the the grandmother lives on a reservation, that's all I know. And if it turns out to be an ICWA case, you go ahead and fight the battle in terms of it not being proper for the child to go there. If it's an ICWA case and you don't bring it up, and it gets brought up late in the proceeding section, just miss things up.
Yeah, excellent. I totally agree with you. I think the general question to everyone raises a candor towards the tribunal scenario if you stand there and say nothing. There actually is this weird section in ICWA that says all officers of the court are supposed to report if they believe there is some sort of question. And I've had a number of attorneys who represent children around the country call me up and say, I've come into this information and the child is adamant that they do not want the judge to know about it. What should I do? If you are solely lawyer and you're only representing the child as an attorney and you don't have best interest analysis, attorneys have made decisions in that case not to tell. However, I think one of the conversations you can have is to tell the child, I will advocate for you not going to be placed with grandmother because I agree that you shouldn't be placed there. But I'm going to tell the court that there is a possible ICWA situation because things could be so much worse if it comes out later. And the truth is, it's going to come out. It's going to come out. If the child knows her grandmother lives on an Indian reservation and the agency is doing its job, they're asking about relatives, and it's going to come out. And you might have a case where, as you say, now you have the giant bomb go off because now you're going to have to move the child again. There's going to be all these placement issues regarding that. So it seems to me that even though you have assessed as best interests, this is not in for, I don't want the child to go there. Your disclosure that there might be some sort of an ICWA scenario here that has to be investigated is still in the child's best interests. And I think you've got a candor situation if the judge is specifically asking. Well, I say that. What do you say? Do you feel that you do have to answer the judge if the judge answers in this specific way? One person in Omaha says, I feel like I'm tattling on them, but it is interesting to compare different places. One person in Omaha said, I don't feel obligated to answer that unless the judge asked me specifically. I don't think a general question is enough. There's tricky folks over there in Omaha, huh? I think that's a candor situation. I think that you're going to have to reveal. But I liked how you said it. What I'd reveal is, I know there's a relative on a reservation. I don't have any idea whether that means there's an ICWA situation.
Looking around,
Yeah.
I represent mom. Mom, dad's family lives on the reservation. She said, the last thing I want is for dad's family to get the kids. So don't tell anyone
Yeah.
that we're all on the reservation.
Right.
Then would I say, I'd ask me to keep this a secret, but Judge, I'm going to go ahead and tell everybody here.
No, I would not. I would remind, if the question is pointed to you, that's one where I think the candor to the tribunal section that says that where you believe the judge is violating your confidential relationship, you have to answer that. Your Honor, I cannot answer that question. I have a confidential relationship with my client. Of course, I always think as soon as you say that, the judge knows there must be something. And as I was mentioning, like the woman I was representing the other day who didn't want, I knew the name of the father, but when I pushed the judge, no, you can't make me answer that question. question. I'm not able to do that. It sometimes might bring the judge back to it. It's interesting because, of course, I doubt the judge is thinking anything like that when he just asks this general question. He's just engaging in good practice. Should I be aware if there's an ICWA case here? When I've had that situation with parents, though, I have told them the same thing. You know, they're going to find out. And it might be better if we let people know from the beginning and what your issues are with these people, as opposed to having it come out later. That sometimes the judge feeling that you failed to disclose information makes them really prejudiced against your position in the case. Doesn't matter. That doesn't always convince people, right? All right, how about this one? You've got a 15-year-old client, and the client tells you that when I was on my last unsupervised home visit, I know my mother was smoking weed. But don't tell the judge that. You know I want to go home. You also wanted the child to go home soon. In fact, you thought that was going to be happening soon. And you're actually raising the question in your mind, does this change my best interest assessment? I did think the child should go home. The child is telling me that mom's smoking some weed. My 15-year-old client, does that change my assessment on that? What should the GAL do? Does the age make any difference? Do your best interest analysis and then your lawyer analysis. We've got another example of having to remind the child that you don't keep secrets. Thank you.
Whether or not you feel that marijuana is morally or whatever, doesn't matter. It's against the law. It's subject to parent to imprisonment, legal ramifications. But also, it's considered child abuse to be smoking marijuana during the child. So we have this affirmative duty to report child abuse. So I just don't think you can say that jail understands the mother using a little marijuana is a deal. It is a deal. That's an action report you have to deal with. And I don't think that you have a problem with confidentiality. It's like if the child reported to you that their mother was beating them, but it's not so bad. So it doesn't hurt that bad. So just let them go home.
Yeah. And your assessment is not only that this parent is engaging in something that violates the law, but is it a little further that the lack of judgment that one would show if your 15-year-old is about to come home and you're hoping for that to happen too, letting your 15-year-old be aware whether you're deliberately smoking in front of them or whether you've gone into the room with the rolled wet towel or whatever, or I'm showing my age. If the parent is smoking to the extent that the child is aware of it, it seems to me that that's showing pretty poor judgment on the part of the parent as well as engaging in illegal behavior. So you're saying this would not change my assessment about telling, even if I thought, maybe she's not that impaired by it, because the behavior is behavior that needs to be, it should have some consequences.
Well, I'd be concerned also about the child's attitude. The child has been taught to be secretive about this and not have an actual belief that
It's not a bad thing.
I'm just as concerned about the child's attitude as the most.
And that might be worse in your mind because it's a 15-year-old as opposed to, say, a 5-year-old. The 15-year-old is then aware that from mother's perspective, there's nothing wrong with doing something like this.
I get it from every age. I mean, 5-year-olds draw their parents' pipes.
Yeah.
So it's every age.
So your assessment is that you're going to tell the court what went on, and you're going to remind the child that you are not someone who keeps secrets, and it might, from what I am understanding what you're saying, it might affect your decision about best interest, that you might change your mind about wanting or thinking that the child should go home relatively soon. Great. Anybody feel differently?
Smoking, assuming that the parents being tested, at least in Lancaster, if they're in court because of drugs, we test them left and right, and it's positive they don't test. So is that not just a guess, you know, you could find out if your THC there or not. Number two is, if the parents have relapse, you can deal with that before. Part of recovery is dealing with relapses. Doesn't mean the child can't eventually go home, but we may have to back up a little bit. We may have to put some different safety things in. But definitely that has to be addressed, especially if that's the underlying, you know, basis for the adjudication. And it's not the end of the world, it just has to be dealt with.
But it may be, and what you're saying to me might be something that you're saying to the client. You've told me something, it is something I'm going to have to disclose. It's not the end of the world. It doesn't mean you're not going to go home. It might mean that that's delayed somewhat, but we're going to have to deal with that situation. Would you immediately bring it to the court's attention?
You know, if it's part of the court order that says you shall abstain from the use of controlled substances, possession or use thereof, or alcohol, I'm going to do as guardian ad litem what I think is the best interest for the child, okay? And that would mean that I would, you know, I would ask for a review hearing. Now, there I'm stuck with the proofs. How do I know mom is, you know, done marijuana? Just because the kid said it doesn't mean that we know for sure. And, you know, that's where the testing comes in. And believe me, the parent's attorney is going to be right in your face. So if he says that, well, maybe the kid doesn't want to go home right now, so well, where's the proofs? So you got to think about all of that when you go in. I'm always, I would just bring it in front of the court and let the evidence play itself out.
But I agree, and I like what you said about making sure to sort of talk about this fact that it's not the end of the world, that it doesn't mean we still don't have the same intent here. You want to go home, and I want you to go home, but we need to figure out what's going to work. And going home in any situation where you're going to come right back in because somebody realizes there's still some problems in that household is not going to be a good idea either. What about a situation where the prosecutor says to the judge, mother's no longer using drugs and the child can go home, and you have just received some information from your client that mother was smoking marijuana when she was last home? Do you have to say something when the prosecutor says that? Prosecutor wants to send the child home. Your best interest analysis was that the child should go home, but now you've learned this about the marijuana. I think, I see some heads shake. I mean, candor towards the tribunal, I do not think you can stand there silently when the prosecutor says that. Even if your position is still, I do want the child to go home. I don't think you can, with that information, stand there when the prosecutor says that. And I'm curious because this is a very, very hot topic on the training circuit now around the country. I'm sure that you have court orders sometimes that talk about a parent not being under the influence when they're going to have a visitation. What do you think about a scenario involving the following? A parent is told that they will be denied visits if there's a dirty urine analysis, and they have a test on Monday, and the test is positive, and the visitation is scheduled for Thursday. Is the visitation on Thursday canceled because of the positive tests on Monday?
That's kind of one of my pet issues as a parent, is that absolutely not. I think it should only be if there's behavioral evidence that the parent is inappropriate, or if they have a UA immediately before.
It's Thursday morning and they're testing positive, and the visit's for Thursday afternoon. Yep.
Absolutely.
Yep. Others feel that way as well? I'm betting there's some people who feel differently. What do you think, sir? Unsafe, yeah.
Well, I'm looking at the question itself, and it says to me that that's the wrong way to look at it. Should the parent be denied visits? If I'm GAL, I would ask the question as, should my child be denied?
Yeah.
Because it's really the visit intended for the benefit of the child.
Yeah.
I don't care about the parent unless I'm the parent's attorney.
Yeah.
And that But denying the child the visitation of the parent, if there isn't a real risk of harm, if they're not under the influence, then I think it's wrong. Advocate that the visit go forward.
I'm happy to hear you say that, because I think that is an issue that is the reason I'm asking this question in the middle of an ethics discussion. Because I think this is a Yertle situation. That child is entitled to see their parent. It is a right, I believe, that a child has. And it's an analysis about whether it's safe or not. And to the extent that, that visitation is being used as a reward or punishment for the parent, it's unfair to the child. So in this duality that, that you have, I think this might be best interest, but I sure think it's rights. It sure seems to me that as an attorney for that child, that you should be arguing that a child has a right to this visitation, and as long as the visitation is safe, whether or not the parent is making changes shouldn't deny that. I think that's really important.
It also makes a difference as to how the visit is supervised.
Yeah.
Fully supervised visit, is this a monitored visit, is this a no monitored type visit? I mean, clearly, if there are concerns about the parents' sobriety, then it needs to be fully supervised.
You know, there could be a situation, could there not, where even though that morning the test was positive, the assessment by the caseworker is, this person's been using, but I don't see that that's going to pose a safety risk in my fully supervised visit. It's one thing if she's holding on to furniture and we're talking about not letting her have a visit where she's going to pick up a baby and fall with the baby. Now this one I think is more controversial, because some people have argued the child seeing their parent under the influence of anything is negative for the child. Other people have argued the child's probably seen their parent under the influence more than anybody else has, and as long as it's done in a safe way, the child still gets that connection that the child has a legal right to. No more argument about this one. This usually causes a lot of people to say, no, I don't believe it. What I find interesting is when we discuss this topic with judges, a lot of judges don't feel this. A lot of judges are like, no, I told their parent not to use. If they're using, they're not getting visits. And some of them really do, I think, have a hard time thinking about it through the lens of the rights of the child, and it may be very important for you to bring that to the judge's attention. Okay. What about this one? The GAL tells the judge that Marcel doesn't want to go home. And the caseworker whispers to the GAL, that's not true. That's not what Marcel is saying. What should the GAL do? And does it make any difference if the GAL hasn't seen Marcel since the last hearing or hasn't seen Marcel in the last few weeks? Part of your obligation is to let the court know what the child is saying. You think you've done it, but the caseworker whispers in your ear, no, that's not what the child is saying. What should you do at that point? Is there anything you could do to sort of prevent such a thing from happening?
I think to prevent it, and one thing is, and I know we all get busy and we're running people in the court, but it's possible to try to have a conversation with everybody before the hearing starts. And then I think if that situation does arise in the middle of the hearing, then one option, I mean, I don't know exactly what we should do, but maybe one option is just to say, okay, judge, the caseworker just told me this. My last conversation with my client, who told me this, and tell him the last time I had this conversation was 2 weeks ago, whenever it was. And then I guess the judge take over from there as to how they want to proceed.
I think all good points, speaking to everybody ahead of time, letting them know what you're intending to say to see if they may say something different, telling the judge right away that perhaps your current statement may not be the child's most recent position. I think it's a good reason why I think if it's a permanency hearing in particular, that it's good to have your client present. Because if your client's there, you can ask your client what's going on. The other thing I think it stresses to me is when you're going to have a hearing where such an issue may come up, then you have to do what you possibly can to see that child before the hearing. People do change their minds about positions. If you can't see them, maybe you can telephone them. Don't forget that I'm going to be in court today. Is there anything else that you want me to tell? It would be awkward, would it not, to have to tell the judge that you in fact hadn't seen the child in quite some time, and that was then you didn't know what your client's position was at all. I guess in another scenario, you could also ask the court for an adjournment if you thought it was a pretty significant thing to get that information in, or ask the court or advise the court that you will give a final information about that in some sort of a subsequent proceeding or a subsequent report. That might be a good idea as well. What about the situation that the reason this is in fact happening is because Marcel told you something different than he told the caseworker? Does that happen for you, that you find out that the child is saying something different to you than they're saying to other people? Happens to me a lot. Happens to me a lot. I think to a certain extent this sometimes demonstrates a strength that children have in a weird sort of way, in the sense that when they're vulnerable in these positions, particularly when they've been moved out of the home, they do sometimes tell people what they think people want to hear as a way of sort of getting along. I do think it's important to ask children, when you're asking them about their position, whether they've told that position to other people or whether they've told a different position to other people. I think it's unusual for a child to tell a foster parent, for example, that they want to stay in the foster home, and to tell a birth parent that they want to go home. And then, the sides are accusing each other of lying, and sometimes the client admits to you that they did just that, tell them different things. What about the child who says, I do want to talk about what I want or what I don't want, but I want to do that privately with the judge. I don't want to do that in front of people. I don't want my mother to hear that. I don't want the caseworker or the foster father to hear what I have to say. What's your obligation at that point in time? What do you think? Can a child talk to the judge privately? Is that something that happens around here? Will judges allow that?
I give them a big caveat that I would ask the judge, but I will tell you, the judge is not going to allow you to do this unless at least your parents' attorneys are here. We have done that before, when the parents are excused and the attorneys are here. Those are the ground rules, so just be honest with the child as to what the abilities are. And just say, if none of that's feasible or comfortable to you, then I can present your position to the parties without having you actually have to say something.
The judge might be willing to talk to you without your parents present, but wouldn't do it without the attorneys present. Has anybody ever had a case where the attorneys have consented to the judge talking to the child without any of the other attorneys present? With the consent of everyone or without? There wasn't any consent. There wasn't any objection, sorry. That might be possible. You might raise the question as to whether or not it would be possible that people might consent. They might. Attorneys might make a decision that that was a reasonable thing to let the child talk to the judge. I think, yes, sir.
What do you do if the child says to you, I don't want to go home, but I don't want my mom to know?
Huh?
And so I want you to oppose me going home without telling the judge that I don't want to go home.
What do people think? This is, I think, another one that really impacts the duality. You hear the child say that I don't want to go home. Maybe and what's your posture in the case? Are you agreeing with the child that he shouldn't go home?
Well, I think that's one where the child's feelings are really important, because you really have to, I think, get to the bottom of what's the problem. And I think it depends to some extent on what's the problem.
I think the thing I talked about earlier is something to think about, and that is how much of your best interest analysis does rest on what the child wants. I don't think it's what I want, what the child wants. I don't see it that way sometimes. What you think is best may be based on some way the child is feeling. As I said, a child who really doesn't want to go somewhere and who's old enough to make sure that that feeling is acted upon in his behavior is a child who I think you have to analyze that, whether that's in the best interest. Is it in the best interest to send a child home who's adamant they don't want to go home? And so I think that that's part of your own analysis as to where you go. But I do think you've got a little bit of a problem in the sense that you can do what this woman recommended here, make it be your position, Your Honor. I don't think the child should go home, and here are the reasons why. But it's pretty clear to me that you are to tell the judge how the child feels. I think it's possible how the child feels in such a case is, Your Honor, my client does not want to talk about how he feels to the court. And then you advocate the position of not return home if that's your best thing. I mean, I think that's the analysis to the child is you understand that I won't be able to tell. You're asking me not to tell the judge what you feel. If that's what you're saying, then I won't tell the judge how you feel. I can make the argument. The bigger problem, I think, will be is the child doesn't want you to tell how they feel, and you don't have their same feelings. You have different best interest feelings. Then I think you have to say, the judge will not know how you feel because I'm going to make my best interest analysis. It's not supporting your position, and if you aren't willing to let the judge hear your position will not be known at all. Yeah. Do you think that scenario is a case in which you would consider asking for the child to now get an attorney?
Really, if the best interest analysis says the child ought to go home, the child doesn't want to go home, I think that is more important than I asked the
Or vice versa? It doesn't matter what it is in the sense of you believe the child should not go home and the child is adamant about wanting to go home? Is that enough? Yeah. I feel like I'm just looking at people when you're saying that, and I feel like people either don't agree with that or maybe haven't thought about that before. I'm leaving, you can talk about me after I've left, that crazy broad from New York, what's she talking about? I'm just asking, I'm trying to be a little controversial here. If that is happening in your cases, you've assessed the child could go home and the child says, I really don't want to, or you've assessed that the child, or vice versa, you've assessed that the child shouldn't go home and the child is really asking you to go home. Is that a situation where you think there's enough of a conflict to have attorney appointed to make whatever arguments the child wants made?
The word reality may intrude here.
And?
Well, I mean, sometimes it's just not in the child's best interest, and they're just not being realistic about it.
It's so unrealistic to you that you see no point in them getting counsel. There's nothing counsel could say on their behalf. You can't return home if, the only parents you have are doing life in prison. I mean, if it really is that unrealistic.
Another thing to think about is too is the age of the child. It's 17 and it's a lot friendlier and great pastures are with the foster parents that have big TV screens. And they can take a child out to the garden and fifth wheeler. And the mother and the father correct the problems and the child just doesn't want to go home. Then, that's another thing that we have to think about. Because there is a concept out there that children cannot divorce parents.
Yep.
That, that you can think about. It depends on what your is.
Yeah.
If it's a 9-year-old who really doesn't want to go home, well, there's something there that needs to be explored, and however you can get to that judge and the other parties that are sitting will need to know what those issues are, because they need to be resolved in order to make that family reunification successful.
Not going to come back in. Yeah.
Conditions there.
Yep.
Both ways where some teenagers just didn't want to go home because it was green on the fence with the foster parents.
Yep. It is hard, though, isn't it? I mean, it's the difference between a child and an adult, but if you're involved in a matrimonial and somebody wants a divorce because they just think there's hotter, better, younger people out there, that's a pretty disgusting reason to get a divorce, but you have a client who wants a divorce and you help them get a divorce. So the child wants to stay in the foster home because they got Xbox and a nice pool. You think that's a bad reason to want to stay, but does that child have a right to have somebody articulate that reason, argue for that reason?
Because that's when the judge can determine the maturity and the thinking ability and the insight of the child. And the judge needs that information in order to put whatever weight he's going to do on that.
Yeah.
And whether you're guardian ad litem and you have a different position and the child, somehow that issue of where the child's coming from and why they are needs to get to the judge.
Yeah.
Because he or she is being paid to make those decisions. And to some extent, we need to make sure that the kids' ideas and perspectives are heard by the court, so the judge will put whatever weight it wants on, with due respect to the child and the judge is talking to them.
I couldn't agree with you more. I do think it's a challenge, though, because the more you analyze for the court why you think the child's position is not a tenable one, the more you are best interesting, but not at all looking out for their legal rights. And I think that makes it hard. If I say to the judge, in my opinion, in my report, I think the reason Johnny wants to stay is because of the Xbox and the pool, and I don't think 14-year-olds get to say who they're going to be raised by, or we'll all have 14-year-olds being raised by crazy Hollywood actors or something. The more you're in what is really a very bizarre position for an attorney, in effect, doing what you can to submarine your client's perspective. And I don't know if at what point in time you're now saying there needs to be somebody else in the picture. All right, here's one that should get people worked up. The police call you up and say they would like to talk to a foster child client who's in placement due to parental neglect. They're not in placement due to delinquency, but parental neglect. But they want to talk to him about some neighborhood burglaries. And they're asking you to help bring the child down to the police station so they can talk to you. What's your assessment? Are you going to help? Are you assessing that it might be in the child's best interest to cooperate with the police? I've had this one. I always think the police are crazy. What are you, crazy? In all of our analysis about best interest in attorney, I believe this one has to strike you in the heart. Doesn't this one at some point say to you, no? I'm asking, are there people who feel they would assist the child to go down to the police station? Is it in the child's best interest to fess up and take what's coming for them, or what? Is it not your problem because you're only representing the child on the child maltreatment issue? That'll be the problem of somebody else who might have to represent them on a delinquency matter. Well, I'll be controversial, I guess, and say, no, I wouldn't cooperate at all. I'd say, hell no, and I'm putting you on record that this client has a lawyer, and you're not to talk to him, and I will immediately deliver a letter that says that you better not talk to him, and I would be lawyer all over the place there. It's very hard for me to decide how it could ever be in the child's best interest to go and confess to the police. Somebody tell me no. I'd like to hear an argument otherwise. I don't know. Maybe people don't feel that way.
I think that's our decision. I think it's very right, that's our decision. We're not their guardians. We're not their parents. And I think that falls in the position of guardian or parent.
Okay.
And we as guardian should do that.
So who are you going to refer the police officer to? Who should make the decision? Should it be the agency? The child is in foster care, so the child is in the legal custody of the agency. Would you say it's the caseworker or the agency's decision whether to bring the child down to see the police?
And the custodian, that is a responsibility because that is, the substitute parent here. And a parent has an absolute right to have a child cooperating or not cooperating. If the law enforcement officers, at probable cause, that gets into criminal stuff. But, I think that the point person on that discussion would be the legal custodian.
So your answer to the police would be, this is not for me to decide, you need to call the caseworker.
The legal custodian.
All right. Next door to you is...
Doing that, like jail, I'm going to say, and the officers come to me, I may privately think, why is he talking to me? But I am not going to direct them anyways. I'm going to say, no.
Yeah.
I don't think it's in my client's best interest.
One of the statements in the Supreme Court rules is talking about attorneys operating in an emergency situation. You practice a certain kind of law. I know you've had this happen to you. You get the crazy relative who calls you, in the middle of the night, and the cops have stopped me, and you don't practice criminal law, but in an emergency, it feels like an attorney might need to do something. So I think your response is, whatever's going to happen with this afterwards, right at this moment, I'm the lawyer for this child, and I need to tell these police officers no, that they're not going to talk to this child. This is interesting to me. Are people willing to do hands up? I have this cool thing in the judicial training where they have this little clicker, so they don't have to admit who's actually saying something, and I ask the question, and then they click up on the board, and then you can see what it is, because the judges don't want me to know what they actually would rule. How many of you would rule this? I'm asking, how many of you, in this scenario, your answer would be, you are not going to talk to this child, I'm the lawyer, I'm making that decision right now. How many of you would say, this is not my decision to make, you need to call the agency, I'm not responsible for this issue? Okay.
Let's say that's the instance you call your client, your kid, say, hey, you don't have to talk to the police, even if the guardian is still in the department, says, yeah, cops will talk about it, you go that far, so you don't have to say anything, right? Because understand, you're not going to get to represent this kid.
So are you sort of saying like a bit of a middle ground, that maybe it's the agency that's going to make the decision, but I'm going to tell my client, hey, you'd be crazy to talk to them and they can't make you? Yeah. You wonder if the kids watched enough TV to know. Let's twist it a little bit more. The GAL finds out that it's already happened. The GAL finds out that the caseworker was asked, and you weren't involved. Nobody told you ahead of time. They've already brought the child to the police station for a discussion. They didn't tell you that it was going to happen. Are you going to do anything afterwards? So the caseworker brought the child down to the police station. Maybe the child said some things that now put the child in a bad position, but in any event, nobody asked you ahead of time. Are you going to do anything about it if it's already been done? Does it make any difference in your mind if the prosecuting attorney told the caseworker to take the child down to the police station and basically not to tell you that it was happening?
Well, there are steps to protect against statements made in the press, those kinds of things. You can ask that the youth be appointed a criminal defense attorney or defense attorneys so that they can move to suppress statements that were taken properly.
So you might make sure that you found out who was assigned to represent this child in the criminal matter, in the delinquency matter, and say, you need to know there was counsel, and it appears as though I was deliberately not asked, and there might be a... Right.
What precautions were taken now?
Right.
I think Mr. Dalton's comments too about telling the youth that they don't have to speak, they're not required to speak, is an important part of it.
Yeah.
Process there, because I don't think just saying to the police officer, no, I'm not going to give permission for you to speak to my client. I might then understand, well, the police are not likely to stop there. They're going to go to the caseworker sooner or later, or the prosecutor, and they're going to go to my client. So if I don't have conversation with my client at that point to alert them that they're not obliged to speak to the officer, they're not going to know.
Do you think you have authority to say to the caseworker in the agency that I'm representing this child and I'm telling you that you are not to take the child down to the police station?
I think so. I would take that position.
Other people? Yes, sir.
If you were pointed at a case of like a dirty house case, kid removed his house was dirty, and then you find out that they're investigating this for
Yeah.
Are we appointed as GAO for this kid for everything? And if we spend 3 hours at the police station with the kid, then we file a motion for fee and the judge can order this and anything to do with it. I mean, it's actually outside the purview of what we were doing.
Well, that is one of the questions that I'm asking. Are you an attorney that is going to step in some kind of an urgent scenario, or are you going to tell the law enforcement, you don't have to talk to me, I don't represent this child on anything like that? What would you do for an adult client? You're doing a house closing, you're doing a will, calls you in the middle of the night and says, I had a few beers, just a couple beers. They want me to blow into this thing, what should I do? Would you say, I don't represent you on that? Or would you give them advice? I don't know. That's my question. And the GAL is both a best interest and an attorney. And
I think this statute talks to this a little bit.
Yep.
Guardian ad litem statute.
yes,
The guardian ad litem shall have the duty to protect the interests of the juvenile for whom he or she has been appointed and shall be deemed the parent of the juvenile as to these proceedings with respect to which is the case. And then it talks about is the guardian ad litem is not appointed to defend the parents or other custodian who shall defend the legal and social interests of the juvenile.
right.
I mean, to me, that sort of
Tell the parents,
more of an answer to
yeah,
the question.
tell the police to drop dead, is what you're saying. Yeah, yeah. Did I see another hand up here, or more movement over here on this issue? And I just tell you this just because I find it interesting. I'm in the camp of, you're a lawyer and you should tell this police to get lost, and I would be telling the agency, you can't do this, and I'm going to go to the court, I'll get somebody appointed, blah, blah, blah. I would be pretty aggressive about it, and I feel very strongly about that. In New York, our appellate courts ruled just the opposite the other day and said that the agency has authority to do this. I was shocked. But doesn't stop me, I'm still going to do it. Yeah.
Lack of experience, prior experience with the law enforcement, whether they're, okay, even though Miranda was given, I took it under Jackson v. Down, the voluntariness of the entire situation. And I found that as this court-appointed legal counsel to defend
Yes.
violation, and we did our motion to suppress, and the court found that given those factors that you find under Jackson v. Down, this kid didn't have the ability to waive, didn't have the ability to well, his statements to law enforcement officers were involuntary and therefore it was suppressed. And that was in case one of the elements I brought in was that there was a case manager there saying, you have to talk.
Yes, you better do that. The twist on this one that I've seen in some places is the criminal charge that they want to talk to him about is sexually abusing one of the foster children in the home they live in. And now you've got an agency who's got a real conflict. And then I think to myself, if you don't go down there with a, sword, I really think you have issues. All right, let's take a look at this one. You represent Bobby, who's a 12-year-old, who's been in care for about a year. He loves his foster home, he's done well there, and he tells you that he wants to be adopted. His birth parents have made little or no progress with their substance abuse problems, but the agency thinks that the parents deserve more time. To try to work on these problems. And the agency, the caseworker tells you, this is our thing that we just talked about a few minutes ago, Bobby just wants to stay there because his foster parents are middle class and there's better things there. We're not ready to make this decision. We're going to wait it out. Are you filing the TPR on behalf of Bobby? I guess I should ask, how many of you have filed terminations yourself on behalf of the children that you're representing? I'm seeing a couple hands up. Good, I'd like to see that. But I admit it's probably unusual. In most cases, I suspect you and the agency reach an agreement. This is, actually, that one's coming up. So you've had a situation where they don't want the termination to be filed. And are you assessing as in the best interest of the child that you agree with the child's position that it shouldn't be filed? Oh, you represent the parents. So you're interested to hear what the people would say. Let me say that, let's try it the first way. Your best interest analysis is that Bobby's right. You are analyzing it and you agree that the parents have not really made enough progress, and whether Bobby's motives may or may not be totally pure, you do think that Bobby should stay there. Is it time to file the TPR? Should you file the TPR? Should you wait because the agency doesn't seem completely convinced? Someone described to me in looking at your statutes that they might be willing to wait a few more months, put an outside limit on it, 2 or 3 months, because the TPR would be easier if it was brought at about 15 months than at 12 months, and with the agency not being particularly supportive of it, that it might be better not to be premature, wait a few months to do that. I don't know if you feel that way, but I guess one of the issues I'm trying to tease out here is that a 12-year-old who's articulating that to you, making it pretty clear this is what they want, seems to me that you have to provide some response. Yes, I'm going to do that. No, I'm not going to do it. It's going to be best if we wait a couple of months. What if your assessment was the opposite? You agreed with the agency. It's not time to free this child for adoption. There still really is hope that the child should go home. And Bobby's asked you for this. Is it time to hire an attorney for Bobby, or do you think that you can wait a few more months and see how things go? He says he wants the TPR filed. You think it's a little premature.
One of those instances where maybe it needs to make sure that everything's clear and there's no ethical questions that arise if you ask for an attorney. This is something where it's not just, well, I want to go home, but it's not that sort of, it's, I don't want to go home. I don't want my parents to continue to have an opportunity to address their issues, since I think it's clearer.
You think at this point that you would be asking for an attorney. He's made a very clear statement about what he wants. You're not at that point yet, and you think somebody needs to be looking out after his legal interests at this point. Yeah. I think a conversation with Bobby and seeing if that is what he's in fact saying, I can ask about it. One of the things that we haven't talked so much about is talking to the child about whether they want to get an attorney appointed. And maybe saying to Bobby, one of the things I can do is ask for an attorney to be appointed to do that. Let me tell you the reasons why I think maybe it would be better to wait a few months. If we wait a few months and they're still not doing what they need to do, I would bring this for you, or I would make sure you got an attorney at that point. I like the idea that if the child could be this articulate with you about why they want to do something, or the fact that they want to do something, that you're at least going to have a conversation with them. Do you want me to ask for an attorney to be appointed? What about a situation, let's say, where you are in agreement with Bobby that you do think that a termination needs to be filed? Either you're going to do it or you're going to convince that agency to do it. But you don't just have Bobby as a client, you also have Bobby's 16-year-old sister. And let's just put her in the same house with Bobby, they're in the same place. But the 16-year-old sister says to you, I don't want to be adopted. So you have Bobby who wants it, that you're thinking you're going to file a termination on, and you've got his older sister who says, I don't want it. Is there a conflict? Do you have to, conflict between the two children? Do you have to ask the court to appoint a separate GAL? If you do, for which one? Why doesn't she want to be adopted? What's her reason for that? And are you saying because that's going to fit into your best interest analysis regarding her? Okay, let's say she says, I don't want to be adopted because I think it's disloyal to my parents, I don't want to be forced to change my name, I don't really want to give up the hope that I could go home someday, I don't want to do it. Do you think there's any conflict now? Can you still try to free Bobby for adoption, do a TPR, and yet still support that his sister not be adopted?
There are a lot of examples of where she doesn't, not wanting her parents to feel better, to feel, really good about that. I don't know if that's necessarily a conflict.
I think that's a very valid point. The fact that they want two different things may not be something that really provides a conflict for you if you can either have a best interest assessment that that's okay, and or you see that from a lawyer's perspective. If we change the rule, change it a little bit, and Bobby says the reason I don't want to go is because whenever my sister and I go on visits, they're still using drugs. They're doing it right in front of me. I know they're still using, and that's why I don't want to go home. Do you now have some information which causes a conflict in any argument that you're going to make either for Bobby or for his sister? I think that's what you're getting at, if you've gotten some information. The reason Bobby doesn't want to go home is he tells you they're still using drugs even when I visit. You now have to get out of the sister's case? I think you should talk to the sister about what she means when she says she doesn't want to be adopted. She could not want to be adopted, but also not want to go home. If her desire is to stay as a foster child, age out of the system, APLA, as we say, then you still don't have a conflict, I don't think. If her desire is, no, I'm going home, then I think you have a problem. Because now you have one client who's told you information which is going to directly impact your ability to represent the other client. In the issue of having 2 or 3 children, I think you have this yet another layer that can cause you conflicts about best interests versus being the attorney. Because when I've got a 16-year-old who has a strong feeling, even if I have a best interest analysis, I think you're weighing more on the side of representing that person as an attorney and how much their expressed feelings are going to impact whether they can stay somewhere, be a runaway, have a problem with behavior. I think you've got a real complicated problem in that situation. And when I see that, it makes me think that maybe you need a separate GAL for the sister, and let that GAL go through their own best interests analysis as well as legal analysis regarding what should happen with the sister. In that kind of a scenario, do you feel any particular, do you make any particular decision about which client is the client that you should represent? How do you decide which client is the one that you're going to stay with and which client is the one who should get the other attorney? Yeah, I think that's a good way to analyze it. Or you might actually have a feeling that you are, you've been more effective with a particular client, or client feels more of a bond or connection with you. You might actually even talk to the kids about it. I don't think I can go on representing you both because you want 2 different things. And what do you think? Should I flip a coin, or how will we handle that? Okay. In the same sort of vein here. This one's not uncommon, I think, out there in child welfare. You're representing 2 children. They've been in care for over a year. They're 12 and they're 10. They like their foster home. They're doing well in their foster home. The mother has serious drug problems. She gives birth to a new baby, positive tox, let's say, and the baby has medical issues. The agency immediately removes the baby, and the judge says, okay, now you're representing the baby as well. The 2 older children say, we want the baby to move in with us. We want to be with our new brother. And the foster mother says, I can't do that. I cannot take another child into the home. I can't handle a baby who's got medical problems on top of this 13 and 10-year-old, so I can't do it. What do you do? Is there a conflict between your representation of the 13 and the 10-year-old and the baby? How are you going to analyze this one?
Realistically, I think we need more information. Is there even going to be a foster home that would be willing to take all three to begin with? I mean, how serious are these medical issues? Is this going to be a child that you absolutely are not going to find a place that's willing to take both this baby and other kids at all?
Good, very good information. I mean, I need to know realistically whether or not this is really anything that's an issue. If there's no foster home that will take all three, including the child with the medical condition, then I pretty much have to tell that to these boys, or to the older children, the 13 and 10-year-old, and probably in that situation I'm going to analyze that it's better for them to stay where they are. Other things that you might be able to do to advocate if you had that situation, what else could you do that might enhance all three of your clients' best interests? If there's not going to be a foster home that will take all three.
Make sure to set up sibling visits.
Some kind of sibling connection. And a lot of people talk about getting creative with the caseworker on this. Of course, you're going to need the caseworker's buy-in, but you could have all kinds of options out there. I don't know if you've experienced this, but I sense that a lot of families have fostering and adoption as part of their sort of their family culture. Maybe you've experienced this as well. A grandma fosters children, and her children foster children, and two sisters both foster, and they live across the street from each other, and three neighbors all foster. In my mind, that happens a lot, and it may be that one of the things that you could try to advocate for with the agency is that the children, if they are going to have to be separated, are placed in some kind of situation where the abilities for them to see each other are increased dramatically. Another thing may be to talk to this 13-year-old and 10-year-old and tell them, what if there is a place that will take all three? Are their desires to be with their young baby brother so strong that they would choose to leave the foster home that they are in right now, where they've done well? I mean, they deserve to know some of the possibilities and probabilities, I think, and they might look at the situation differently if you've told them that those were the options to take a look at. If it's true that the 13-year-old and the 10-year-old say, I don't care, you can move us anywhere, we really want to be with that brother, and you really agree that that child, that infant, has serious enough medical conditions that you doubt any foster parent could properly take care of the 3 children together. Do you now have a conflict? I desperately want to be with this child. You've analyzed that it's not in the best interest of the baby for that to happen. I think you could have a conflict in this situation, especially if you've got a 13-year-old who's articulating very clearly what they want, and you feel that that's not in the best interest of the baby. If you're analyzing the best interest of the baby over here, and you're analyzing the best interests of the 13 and the 10-year-old over here, then you may decide that their best interests really are not the same, and that you need a separate GAL. Also might decide that they could be the same if you disagree with the 13-year-old on the issue, 10-year-old, on the issue of whether or not it would be better to leave a foster home where they're all together to be able to be with a sibling. Okay. Let's talk a little bit about coming to court. You've got an 11-year-old client that tells you that she doesn't want to go to a permanency hearing at court. The judge is stupid and treats me like a baby. It doesn't matter what I say anyway. Now, you've got 2 things here to come into play. One, we have a federal law that requires the court to consult with the child in any permanency hearing. The federal law is connected to the federal funding that the state receives, and you don't want to jeopardize the federal funding for sure. But the feds have said consult with the child does not mean the child actually has to come to court. You also have guidelines here that say that you should be encouraging children to come to court and encouraging and assisting them, and that's the best practice under the guidelines. This child doesn't want to come because she thinks the judge is stupid and treats her like a baby. What could you do? How could you try to address what the guidelines say, make sure that the federal law is being followed, but you've also got a client who doesn't want to come to court? Anybody got any ideas? Does anybody do anything different than bring the child to court in a situation where the child doesn't want to come for any reason, for any particular reason the child doesn't want to come? Would your judges be willing to listen to or have a letter from the child come in? I think that might be one way of dealing with something like this, asking the child, why don't we think about what you'd like to say to the judge, let's write it down. Would your judges permit the letter to come in, assuming, for example, all parties could see? I think that's an option. Another option, because there is that guideline asking you to do what you can to encourage the child to come to court, is to talk a little bit to the child about why the child feels that way. I'm guessing it's based on things that happened when they were there in the past. And maybe there may be a way to reapproach the judge when you're in court the next time. For example, we could write something down, and I could tell the judge that you had something you wanted to read or something you wanted to say, and that would maybe help you be in that position. A couple people have even said to me, I might speak to my judge and say that the 11-year-old is having some problems and would need a little bit of special attention when you come in to ask questions. How about the next one? I had this one. I'll tell you, it ended up going to the appellate court, so I'll tell you what happened. But a 15-year-old client has pretty serious behavior problems, is adamant about wanting to go to the court, and tells you what he's intending to do when he's at court. He's going to tell that effing judge what a real a-hole. Of course, the client says these words, doesn't do it this way. He is for putting me in a place like this. If he doesn't send me home, he's going to be sorry. Are we having this child come to court? Is the child's best interest to come there? Is there anything else you can do? In my case that I handled, I'll tell you the little twist on it was that the agency thought this kid was so out of control that they didn't want to bring him to court, and claimed that he always had a meltdown and had behavioral problems after court, and that his usual charming behavior was even worse after he visited the judge. So I had the agency arguing that they did not want to bring this 15-year-old to court. His name was Pedro, by the way. Problem Pedro, I thought of him as. What do you think?
I mean, maybe one of my first reactions, and I think you just kind of sometimes naturally go to the worst case scenario, is from the lawyer standpoint, what sort of position are you putting this kid in if you know he's going to act out? I mean, is he going to rise to the level of possibly even criminal charges? You don't want to put him in that position.
Right.
So maybe it's, how about a letter? Maybe trying to redirect him to another way.
Is it in his best interest to not be there and do this and cause a scene, cause a problem? And maybe if he wrote something up, even if what he wrote was kind of nasty, it might avoid the confrontation. And one of my kids gave the judge the finger one day in court, and the judge was threatening to do something. I don't know what the judge was actually going to do. I just kept trying to convince the judge that that was a new kind of sign that the children give each other. It's kind of a good luck thing. It was a positive thing. He didn't buy it. Yeah, I think also some people have said to me, this is the kind of thing kids say. They go into court and they won't really do this. I'm not really worried. If I knew the client very well, I might know that he says this sort of thing to blow off steam, but when he's standing there in front of the judge, he might not do it at all. But I do think that's an important piece to think about. If I think it's likely he might do something like this, that could jeopardize both his best interest and his legal position, and there might be a different way to do it. I'll tell you what happened in the case. case, this is exactly what went on. I operate in a state where you must follow the child's wishes, so we don't get to have all these lovely discussions because we have to do what the kids say. So I advocated that the child wanted to come to court. I couldn't wait to see what was going to happen if the child came. And the agency put in a really good argument about how this child's behavior is going to be problematic and their child's going to misbehave when he leaves, and it's going to be so hard for the agency to deal with him. He was in a congregate care facility. The judge wrote a good decision, a lengthy decision, and he basically said that my client was a really awful person, real pain in the neck. He said pretty bad things about him. And, you know, so what? So he's going to do this no matter what. If you don't bring him to court, he's going to give you a hard time. If you bring him to court, he's going to give you a hard time. So what difference does it make? He gives people a hard time. That's what he does. When he was really actually quite sympathetic, he went through the client's whole history about what a terrible life he'd had, and basically ends it by like, how can he not give people a hard time? This is the horror of this child's life. Bring him on. So the courtroom is like packed when Pedro comes in. Everybody's waiting, and the kid was like nothing happened. I mean, everyone was kind of disappointed. They thought there was going to be some real action. 14-year-old client tells the GAL, I don't want you to be my lawyer. You always tell the judge something different from what I want. That's not what lawyers on TV do. You are a bad lawyer, and I want to talk for myself. It's kind of sad. I'm a bad lawyer. What are you going to say?
Basically, I asked him what we're telling him that he doesn't want. There's some legitimate stuff that he wants to happen that's different than what you're telling him. You got a legitimate case to have an attorney represent.
You want to analyze what it is that he's saying he wants, and if he's saying things that are, you know, have some legitimate, they're not crazy things. I want $1 million in a helicopter.
I think that's maybe matters a little to him, but it brings things doesn't. You can maybe actually have a conversation with God, explain to him why that maybe is a big deal. But if it's something that actually matters, then yeah.
I think you do want to ask that, and I also think, to whatever extent, even if you're going to ask for an attorney, that you could have a conversation about what you're doing and why. I mean, at least try to leave him with the impression that, you know, there are adults who are doing their jobs and they're caring people, and although I may not be what you think TV lawyers are, it's because I'm not supposed to be a TV lawyer. I'm supposed to be a guardian ad litem. Another thing I think you can do is to give the child, again, some positive feeling, even though you're probably going to ask for an attorney, is to show him that you did say what he wants. You know, don't you remember, here's the report I filed. It says right in here what you want. I'm supposed to do something more than just that, and I did, and I'm not going to, you know, tell you that I did something different. I did take this best interest position, but I did tell the judge what you want. But if you are feeling this way, then maybe it's time to think about, and let's talk about what it would mean if I asked the judge for an attorney for you.
I would take it personal because 14-year-olds, their attitudes kind of fly away anyway. You know, sometimes if you take them, if they would go to court with you, you just have them say what they want to say to the judge. You know, you ask them some questions and you let them say. That sometimes will solve that. I don't know that asking for another attorney
would necessarily help.
Because, you know, there's sometimes when they like you and there's sometimes when they don't. Because they don't like anything. You know, it's just, I think that you just have to evaluate that.
I think that's a good idea. Let him come to court, let him say. It is interesting if he came to court and said to the judge, I don't like my lawyer, she's a bad lawyer, I want a lawyer, a different lawyer. It'd be interesting to see what the judge does about that. Again, sort of comparing and contrasting it to an adult situation, I'm sure that you are aware that when there's assigned counsel in particular with adults, it certainly isn't unusual for the adult to come in and I got this lousy lawyer, and why don't I have whoever the best lawyer is in town? Why don't I have this person? Why do I have this assigned attorney? And that happens. And in many places around the country, there's a sort of a response by the court. They're not going to just, you have a right to a lawyer, but you don't necessarily have a right to the lawyer you've chosen in the context of not being able to afford one. And so there may be some feelings about that as well. I operated as a public defender for a number of years before I started doing family court work, and we called it the one punch rule, because basically our judges would say, look, unless the client has punched you, just not liking you is not going to be enough. We'd go around and go, oh God, I hope this one punches me. I really hope this one punches me. So I think that might be another thing. Another thing you could consider doing is saying, okay, I hear what you're saying. Let's tell the judge how you feel. I'll let you talk to the judge about this, and we'll see what's going on. I do like the idea, though, that you try to get to the bottom a little bit about what it is that the child wants that they think you're not trying to get them. And if there is something specific like that, that maybe you are going to support their request for a lawyer that's going to represent their legal perspective. Okay. This one, I'm very interested to see what you guys say. You've made several home visits to your clients. They're living at home, or it doesn't matter. This could be a foster home or their own home. It doesn't really matter. But you're shocked at the conditions in the home where they're living. You're questioning why the agency hasn't taken them out of this particular home. It's so dirty. It's got a lot of unsafe issues, safety issues. And you've gone to the caseworker, and you've told the caseworker, and you're a persuasive, great lawyer. You've told the caseworker, this is what I'm seeing. I think you people need to do something. And now you've got the caseworker board on that as well. And the caseworker's gone and said, we need to pull this child out. And the prosecutor's going to bring this to the court's attention. And the prosecutor says, okay, I'm going to subpoena you. You're going to be the witness because you've seen this stuff. My caseworker couldn't even, couldn't get there and see all the stuff, or wasn't available. House wasn't in that bad of a shape. You're the obvious witness. I'm going to subpoena you. Can she subpoena you? What happens if you're subpoenaed? Does it matter to you if you are supporting this idea? I want the children to be removed. Are you going to fight the subpoena, not fight the subpoena? Is there another way to approach this? Should you be a witness in this case? Anybody have this happen? Has anyone been a witness in a case where they were also the GAL? Do you think that it's ethical for an attorney to also be a witness in the same case that they're appearing on? Is there something about that that makes you a little uneasy? Or are you sort of a witness anyway, since all of your opinions and reports come into evidence? I mean, where is the line between that and actually testifying anyway?
Well, I think there's big problems with testifying. I just do not believe that we can testify in a proceeding as a guardian ad litem in your role. I think that actually that you would be protected, that you could file an objection to the subpoena. And even if you're ordered to testify, I think that you may not want to testify in court. And as far as the reports go, my belief is that, the way I justify submitting a GAL report as evidence is that I do not include factual information in the GAL report. I will include what statute requires, which is, who I contacted, who I talked to, what reports I've reviewed, and here's my recommendation. That's it. I don't
Put factual material in here. Yeah.
So they told me this.
And I believe him or I don't, yeah. Now, I've forgotten, I thought it was someone at this table who said that you're in a position where if you submit a report, in effect, you're allowed to be cross-examined. In a way, you're like a semi-witness, so to speak.
I disagree with John.
Okay.
I think I can submit evidence just like anybody else, subject to everybody else's right to object. I can attach police reports, raid reports to my GAL, and I don't consider that testimonial because I'm offering it as evidence. If they want to object, they can object.
Would you?
I'm talking about me giving evidence,
Yeah.
not submitting a report.
Yeah. Well, although I think you're saying, yeah.
An affidavit.
Yes, but you're also saying that you're careful about how you write your reports so that you're not, in effect, offering evidence.
Because you have an ethical obligation not to testify as an attorney in a case, and there's in this dual capacity in Nebraska,
Yeah. Yeah.
And that's where I agree with John here that we need to be careful.
That you would say to the prosecutor, I'm not going to testify, and if you attempt to subpoena me, I'm going to oppose it.
Yes, and I may ask the court then in filing my motion for protection to also, then, if you're going to compel me, Judge, then appoint
Another GAL. Yeah. That may be one of the options to argue. If you're going to, if there really is no witness, and I'm the only witness, and you're making a decision that I'm going to have to testify, I don't think I can be an attorney in the case anymore. Sir, do you feel differently?
I guess saying that you go to the house is my mistake, my cemetery, the place that you're not going to put that evidence in your report?
The question he's asking is, I've seen the house, it's a disaster, wouldn't I have already disclosed that in my report, that I saw these things and that it was horrible and that I think the children should be removed? Doesn't the judge, in effect, already know what I have to say?
You are basically testifying as to what you observed by putting it in your report.
Well, I'm not supposed to put it in the report. I'm going to say the kids shouldn't go home, period. And tell the caseworker to go look at the house, call the caseworker as a witness.
A number of people have come up with ways in which they sort of feel like they could get out of this and still achieve their goal. For example, I'm going to ask somebody else to go to the house and tell the prosecutor, you need to subpoena this person. I will bring a witness myself when I go to the house if the caseworker hasn't gone, and let that person be subpoenaed. I will put it in my report. Interestingly enough, a number of people said if it was in my report and accepted as part of my report, my judge might take the children out without any other witness testifying, just use the report. I don't know if that would happen here, but it certainly is something to think about. And if you are going to be in a position where you get compelled, then having this discussion about whether or not you should be removed as the GAL. 12-year-old discloses to the caseworker that she's being sexually assaulted by her stepfather. When you talk to her, she tells you the same thing. And then you talk to her brother, 15-year-old brother, who you're also appointed to represent, and the brother tells you, I know my sister is lying. She told me she was going to make all of this up. Do you have a conflict? And who, if you do, which one should you represent? She says she's being sexually abused. The older brother says, she told me she was going to lie and make that up. I almost want to say, this one just shouldn't be that hard, really. I really think it's a pretty obvious conflict, folks. I do. You know, he's saying to you that she's lying. Not that she's mistaken or that he doesn't think it's happening. He's saying that she's lying. I think you've got a conflict here. And I actually would ask you to consider whether or not you need to get out of both cases. Okay? Oh, good. All right, then we'll move on. We represent a 17-year-old. I did want to make sure we talked about this one in our last minute here. You represent a 17-year-old, John. He has a 2-year-old sister, Sue. Mom has a long-term mental illness. She's not in treatment. She's not taking meds. You're well aware that the agency is going to file a TPR and wants to get both children freed for adoption. 17-year-old John is adamant to you, I do not want to be adopted, and I want to go home with my mother, and I want to bring Sue with me. And he's been sort of the parent figure for Sue. You think, based on his adamant position, that it's in his best interest to actually return home. He's 17, he can handle the situation. But you don't think the 2-year-old should go with him. Do you have a conflict between the two? Can you advocate for John being able to go home and not Sue if John's position is he wants Sue with him? Or do you have a conflict and need someone else to represent one, if not both?
I think you got it out right there. I think, there's so many things. What kind of mental illness, long-term mental illness has it been? He's 17, nobody's filed a termination yet. It really kind of depends on how stable the mother is. But in reference to the infant or the 2-year-old, that's a vulnerable, person, and not a 17-year-old, and mom's long-term mental health illness may preclude her from discharging appropriate parental responsibilities for the child that young. that may be a place where you take the 17-year-old advocate, get into the GAL and deal with the 2-year-old.
You might also, I think, be able to talk a little bit to John and ask him, sort of to weigh things for you. You want to be able to go home. I'm willing to support you on that and argue that for you. Is your relationship with Sue so important to you that if I'm arguing that Sue isn't going to go home, that you're still taking the position you want to go home? I mean, that may be something that you have to discuss with him. If he says yes, I think then you're in the area of having a conflict. But I think it would be worth some discussion about whether or not there wasn't a conflict. He might say, no, my desire to go home is strong enough that's all right with me. That's a possibility. I think that it's also quite possible that he says, no, I want to go home, and I want to go home with Sue, because I can take care of Sue, and I want somebody to make that argument for me in court. And in that case, it seems like you may end up needing to, if your best interest analysis comes into play, you might need to take care of Sue and let someone else take care of John. Let's do this last one, because we're down to the last minute. I know you're all going to groan. You wish you could do more, huh? And we talked a little bit about this, just briefly. You're on a home visit to see your client's mother, who has a lawyer, is present, and she says to you, can I talk to you about how the children are doing? Is it okay? Can you talk to her about that? She's got a lawyer. Her lawyer's not present. I know some of you told me earlier that there's sort of a presumption or an assumption that you all practice under, that it's okay to talk to caseworkers. Is it okay to talk to parents without sort of a specific okay from the attorney? Or does it matter what it is they want to talk about? What if she says, can I talk to you about the case? That's a no-no to me. I think it's arguable, based on what you've been telling me about sort of how the culture goes here, that mother saying she wants to talk to you about how the children are doing could be something you could respond to, maybe with a caveat. Yes, I'd like to hear what you're thinking about, Johnny's school problems or Sue's medication, but I need to caution you, I can't really talk to you about the case. You have a lawyer. That might be okay, and then stop her if she starts to talk about the case. What if she says, can I talk to you about whether the lawyer I have is really a good lawyer or not? I think no to that one. And I know the answer to the last one, because you guys have already told me that the position that most of you have is that the caseworker does not have counsel, and therefore pretty much all of these things are fair game. Although I don't know how the third question would get answered. Is my lawyer a good lawyer? No, you don't have one, I guess, is your answer to that. I do want to say that I appreciate coming here and being invited to talk. I do very much like to hear how people are doing, but I really want to say thanks very much for the good work that you do. I am well aware that it doesn't pay a lot of money. It's the same for us in New York. I know that the work is much, much more difficult than people outside our profession know about, and I think that you should give yourselves a hand because it's important work. There really are young children out there that need that kind of advocacy that we provide, and really I'm asking you to make sure in the work that you're doing that you are taking some time to analyze some of these issues, because I do think you have a challenge here with this dual role, and I want to make sure that you aren't sort of letting one of those roles overpower the other one when, by statute you have both of them to take a look at. And I ask you to consider whether in some situations you ought not to be asking for an attorney if you're feeling as though that's not really getting its fair shake as it relates to best interests. So give yourselves a hand.